A week ago, the unfortunate verdict in Eugen's lawsuit against HYBE was announced. The court ruled that their contract is still valid, primarily for two reasons. First, removing Min Hee-jin doesn't mean Adore became an incompetent company. Second, there's no clause in their contract stating Min Hee-jin must remain with the company. When I saw this, I was a bit confused, because the ruling didn't even seem to address the main argument we've been hearing about. So, let's break down why and where to go from here. The members' main arguments in the public sphere have centered on fairness, trust, and creative vision. However, a court's job is not to decide what feels fair in a general sense, but to apply specific laws and legal standards to the facts presented. So, how can they win this appeal? Winning an appeal is fundamentally different from the initial trial. It's not about re-arguing the entire case, but about proving the lower court made a specific legal error. Lawyers won't be introducing any new witnesses or new documents. Instead, they must repackage the existing evidence to show the appellate judges that the trial judge made a mistake. And here's how Eugen's lawyer should approach. First, the definition of irreparable harm. This is their only way in. The lawyers must argue that the destruction of trust and creative vision constitute harm. The court will only care if the lower judge was legally wrong in not considering it as such. Instead of,
The members are sad. They don't trust HYBE, so it's not fair.
they must argue the first judge was wrong for exclusively focusing on corporate operational competence, while they ignoring the artistic company asset at the company's core. They should add that a human asset whose specific vision and trusted partnership with the artist is so integral to the commercial product that their removal fundamentally damages it all. And this specific harm, the destruction of a creative symbol, can't just be replicated by standard corporate management. The failure to acknowledge this was a legal error in the injunction. Second, the precedent cases. The appellate judge will immediately ask,
Show us where another court has granted an injunction for reasons like this.
this is a huge hurdle. Korean corporate law prioritizes shareholders' rights and clear contractual obligations. The lawyers need to find prior cases where a court recognized the destruction of unique creative trust as irreparable harm in a corporate dispute. If such precedent doesn't exist, their argument, no matter how emotionally compelling, is legally novel and very unlikely to succeed. Can these cases be from outside of Korea? Absolutely. While a foreign ruling is not binding on the Korean court, it can still be used as persuasive authority to support the argument. Is there similar cases out there? I'm sure one of you will find it. At the end of the day, the truth is, their path to winning this appeal can be difficult, but it exists. It will come down to a definition war. They have to successfully reframe the case, not as a simple corporate power struggle, but as a unique situation in the current K-pop industry, one that's being watched worldwide. And if they win, just as Nugent needed a previous case to refer to, this case would become the precedent for so many other artists. Just like the CBX case. Tell me how their initial contract was 18 years long, and now their individual activities are blocked? These Korean entertainment companies, they want to promote K-pop, yet they don't respect the very artists who deliver the culture. Make it make sense.